And thank you to all, because I think we heard a very lengthy but very, very useful and very comprehensive presentation. And I think just to maybe 1 minute to draw some conclusion, maybe what we can take home from here. I guess we all agree that, especially if you accept the separate task concept of the Commission also setting out in the white paper, basically private enforcement will have, we would say, exclusive role in one of the very important goals of competition laws, which is the compensation, as opposed to the other two, the development and interpretation of competition rules and the punishment and sanctioning. And I think right now we are living very exciting times when the private enforcement practice develops in Europe. And I think the main task of the European Union is to somehow setting a kind of minimum standard that this kind of role for compensation can be achieved in any member state at least. And in this regard, I think in developing the system, three guiding principles should be taken into account. One, that the system we develop should be an efficient one. Sorry, Bojana, but it should avoid abuses of the US system, if of course there is any. And third, I guess we learned in the morning when we heard about leniency, but now it's just confirmed. The system should not jeopardize public enforcement because in that case, basically it will be a very kind of vicious circle, because more public enforcement makes possible private enforcement, because most of the actions are follow-on actions. So if we have a system where basically has a bad impact on public enforcement, finally it will lead to less private enforcement. So then the main goal is not achieved. So I give you the opportunity to ask questions, even if we are way behind the schedule, because you might have some interesting questions for the panelists. Please. Is the microphone?
My name is Hüseyin Coşkun. I am attending from Turkish Competition Authority from Turkey. I have two questions, one of them for Madame Rek and other for Mr. Blanke. Madame Rek, my question is about the discovery process in American law. Do you believe in a system which does not include a system as like discovery process? Does any one has any chance to get, for example, compensation without getting proof? Because like the systems in Turkey, the claimant has no chance getting proof, evidence for his case. So he or she has to wait the final decision of the authority, then goes to court. But in American system with discovery stage, the claimant can get the necessary proof. Without the system, is it possible to get any compensation? What do you think about this subject? And after your answer, I think I will get the second question.
Thank you for this interesting question. Discovery is a very important issue, because you are right. The evidence is in the hands of defendants. And the problem lies in the fact that the public authorities' decisions do not contain all the relevant information to prove the damage. As we know, the European Commission or national authorities don't have to go into effect. They don't have to. The public available decisions do not contain any confidential information which could potentially be a proof in a civil damages claim proceeding. Therefore, I do believe, and I am convinced, that without access to relevant documents, you will not be able to prove damages or harm. and therefore some sort of discovery, which, as the European Commission recognizes, can be a balanced one, is needed.
As access to file, maybe
access to file. Access to file, which is subject to court's approval, and it will be a competence of a judge to approve an access to file.
Not the authority, but not the authority itself.
No, the court.
Okay. Thank you very much.
Thank you.
And
one sentence on this. At least there are some jurisdictions where cases were successful and where there is no such thing that you would call disclosure, and Germany is one jurisdiction of it. So I think it's certainly possible that claims are successful without disclosure. That doesn't mean that a compromise may not augment the number of cases and rise the chances of success, but it's not necessary.
Okay, thank you. And Mr. Benke, you have talked about at the beginning. I must say that. Please correct me if I misunderstood. You have divided the arbitration process as commitment and ordinary arbitrations. Insofar as I know, it necessitates a prior written agreement for arbitration in ICC process. I couldn't understand the point. For example, we do not have an agreement with you. For example, we are in a trade, and we have an agreement, and one of us breached it, also breached the competition law. So you claim compensation. I understood this position because there may be a provision in our agreement relating arbitration. But without any agreement, for example, I'm a consumer, and you are abusing your position. So a damage occurred, and I want compensation, but we have no arbitration agreement. How will I convince you to arbitration?
Well, generally speaking, you're absolutely right. There needs to be an arbitration agreement in place between, the two parties that go to arbitration in the end. Now, you can always, ex post facto, after dispute has arisen, go to arbitration by a submission agreement, which means you enter into an arbitration agreement after the event. You're right. For that, you need to convince the relatively other party to go to arbitration. Now, the no-brainer way to convince that party is, of course, look, rather than me dragging you into the courts, you maybe want this dispute to be treated discreetly, so that, away from the public eye. That's part of the idea of arbitration. When it comes to commitment arbitration, though, there's a specific mechanism in place whereby there is a so-called arbitration commitment, which takes the form of an ordinary commitment of all the other commitments of the commitment decision. This arbitration commitment you can find in the decision, in the body of the decision of the relevant regulator, let's say the European Commission. If you want to transpose these commitments into real life, because they give third-party beneficiary rights, then you need to have what? A private law instrument to do that, which I called in my little talk an implementation agreement, which is simply, for example, it's a commercial agreement between, on the one hand, the party that was involved in the Commission proceedings that wanted to, for example, get the merger cleared, and the third-party beneficiary. And this will happen normally after the merger has been consumed. For example, this particular agreement will be an access agreement by the merged entity to the third-party beneficiary. And the arbitration commitment, which was initially in the body of the EU Commission decision, needs to be transposed into what I call, in my writings, generally speaking, a second-order obligation, namely a private law obligation, in the implementation agreement. How do I do that? I just transpose it, make it a term of that particular implementation agreement, and it mutates into what? Into an arbitration clause.
I see.
It's not an arbitration commitment anymore, but it gets transposed into an arbitration clause. And there we've got the arbitration agreement then, which binds, so to speak, both parties.
Okay.
So that's for the commitment arbitrations.
Well, thank you.
Thank you very much.
Any other?
By the way, just one last word on that. This is comparable in a sense also to arbitration without privity before you have the implementation agreement in place, and that's very close to investment arbitration without privity. So there's only a unilaterally binding arbitration commitment, which is unilaterally binding at the beginning just on the merged entity or on the party concerned that benefited from the commitment decision.
Thank you.
Thank you.
Thank you. Any other question? Zoltán.
Hello, my name is Zoltán Maros. I'm an attorney in Budapest at Oppenheim. And my question would go to Mr. Blanke regarding arbitration. You mentioned that an arbitrator clearly cannot enforce a cartel. And what I presume you were referring to the case law of the ECJ and the General Court in Deltafina and AC Trojhan, whereby then an arbitrator would be regarded as an undertaking, as basically a third undertaking apart from the parties, who would then be a party to that cartel of the two undertakings that were the parties to the arbitrations. My question would be, how far can this go? I mean, I imagine clearly you cannot enforce a hardcore cartel, a clear price fixing, market sharing cartel. That's something where I can really see the application of the AC Trojhan Deltafina discipline. But what if the arbitrator makes an honest mistake? He doesn't know that this was an object type infringement, and he thinks that the agreement could be exempted. Will he then be held liable similarly, or is there any development on this in the case law that you know of?
How long is the string? How long is the string? I don't know. No, you're absolutely right. I mean, that's one.
Maybe
of the,
we ask
one of
the
big
Commission on this question.
How long is the string? No, I mean the infringement. I think one can comfortably say. I mean, a cartel infringement is a hardcore infringement. If you are, let's say, if you were appointed as an arbitrator, as a competition law specialist as well, then presumably you should see the cartel when it lies before you, essentially, and you go through the arbitration proceedings. It should stare out at you. So I think if you were an ordinary commercial arbitrator and you do not have any competition law expertise, for example, possibly that may be seen differently then from the point of view of the relevant regulators. So I don't know. There's no precedent case law on it per se. You're absolutely right. It's extrapolated from the Trojhan case, etc. But I mean, going by those cases, there can be no doubt that an arbitrator is someone who facilitates something, like it was the case in Trojhan. And even an arbitrator more so facilitates something than just the administrators in Trojhan, so to speak. I think it's quite clear that there's a real danger for an arbitrator to make himself complicit. Anyway, but you're right. There's no black and white. It's difficult to assess. It needs to be seen. What the courts will have to say on it in due course, if ever it comes.
Thank you, Zoli, for the provocative question. Any other similarly interesting question remains? If not, then I think we should give the floor to the next panel, and I thank you once again, the panelists, for their very good presentations.